welcome to today's webinar. Thank you so much for joining today's session. My name is Joel Comerford, a business solutions consultant here at Lawpath. It's great to have you all with us as we dive into trademarks and IP law, how to protect your brand and business legally. Now, while we wait for a few more people to enter, I'll just add a bit of a disclaimer. We have spent a bit of time. I realize I should probably have my headset on. Thank you so much for joining us today. My name is Joel Comerford. I'm your business consultant, a business solutions consultant here at Lawpath. It's great to have you all with us as we dive into trademarks and IP law, how to protect your brand and business legally. As I was saying to myself clearly, didn't have the headphones in, we have been focusing a lot recently on tax and accounting, naturally because end of financial year is coming up, as well as some late additions to BAS that people were trying to get on top of. It's a very business time for entrepreneurs, as we can all imagine. So this is the first legal-based webinar we've done in a while. And yeah, I've been looking forward to it. I hope everyone else has been missing Damin as much as I have. Now, for those newbies, you're probably wondering who are Lawpath. Lawpath are an online legal, accounting and tax platform. We've been around for 10 years and served over 500,000 businesses in that time. What we generally look at in regards to our demographic is mainly newer businesses. We have a lot of wonderful startup packages to assist those who are just starting out, but we're not limited to that. Lawpath, we're basically there for every facet of the life of your business. Just starting out or considering creating a company or a sole trader business, halfway through your business, if you're expanding, your brand's getting larger, maybe some acquisitions, investors, taking on employees, expanding out of your state, we're there, all the way up until the point where you're ready to retire or sell your business and start something new, we're there as well. So certainly Lawpath aren't limited to just assisting newer businesses. Keep that in mind. If you're at a stage where you need assistance with your tax and BAS, especially around this time, if you're wanting to maybe integrate over to an online accounting software, maybe you're just, tired of your bookkeeper and you have other friends or business partners who are using Xero or MyOb, for example, and you say, I want to get on that too, but you just don't have a strong understanding of it, we can assist you over there. We can assist with setting up Xero accounts, bookkeeping, payroll, invoicing, GST advice, PayYG. We've got all you covered there. If you're deciding to, as I mentioned, to take on employees for the first time, get your shareholders and director agreements in place, non-disclosures, intellectual property, for example, then certainly we can assist you there with the document precedence library, as well as assistance from our legal advice as well. More of that later, but for now, let's go ahead and dive into some of the key factors of today that we're covering. So types of intellectual property, copyright, trademarks, trade secrets, patents, et cetera, et cetera. Some of the things we'll be touching on is books, websites, codes, images, key rights to reproduce, publish, perform, adapt, protect brand identifiers like logos, names, slogans, and even scents or colors, which is interesting. Just topics on whether or not something has to be unique and not already registered in the same category, confidential business information, recipes, algorithms, for example. The list goes on. I could sit here and go about this all day, but I think I'll just go ahead and move on from there. Who are we joined by today for those who are new to us? Our senior lawyer over here at Lawpath, Damin Murdock. Damin is, I'll give a nice little speech. If you're used to Lawpath's legal marketplace before, you may have already known Damin Murdock. He's one of our highest rated legal experts with over 300 five-star reviews. Damin has decades of experience advising startups, SMEs, and growing entrepreneurs in commercial, employment, and startup law. His sharp legal insights and client-first approach make him one of the most trusted advisors on our panel. I don't think I could have said it any better. I think that's pretty much it for me for now. I will be advising Damon's on questions throughout. So, guys, if you have questions, we do have a Q&A at the end if you're happy to wait. We may or may not answer them throughout, so feel free to wait until the end. You can post your Q&A questions during the webinar, or if you just want to wait to the end, as I mentioned, you can do that. But if you have some questions that you really just want to get Damon to touch on, go ahead and put it in the chat, and I will advise Damon throughout the call to go ahead and confer about that. Again, if you are new, we will upload every single one of these webinar episodes to our YouTube channel. Just type in Lawpath on YouTube. And I will be sending out an email with the slides from today's webinar, as well as promotional material and just some topics on what we discussed today. So without further ado, Damon, please take it away.
Great. Thank you very much for the intro. Welcome, everybody. I hope you're doing well today. All right, so today we're talking about intellectual property, some of the pitfalls, what it is, some things that are going to help you in terms of running your business, and in the event that you forgot to have certain contracts, what you can do to protect yourself, what to look for when you're doing a capital raise and people are doing due diligence on your business and things like that. So let's just start with what is intellectual property. It can include your business name, your trademark, your copyright, which it can include computer programs, literary works, like anything in writing, music as well. You also have patents and designs and trademarks. So it covers quite a bit of different areas of law and different legislation. And normally, when you start out your business, the first thing is trying to figure out whether you need to protect your intellectual property and how you do that. And the reason why you want to protect it is possibly to stop a competitor from stealing your IP and starting up a direct competitor, or stopping your employees from doing that, or stopping your contractors from doing that. Or if someone was just to pop up later on using the same business name as you might want to get them to rebrand and change their brand as a result. So copyright is governed by the Copyright Act. It's literary works, artistic works, music works. We're going to get into the different elements of what is copyright and what you need to prove to establish that you have copyright ownership. Trademarks is under the Trademark Act, so it's a separate legislation. It effectively protects your brand. So that's your logo, your slogan, your color, your the name of your business generally. And then you also have intellectual property in terms of design, like Lego brick, or a patent, which we'll get into a little bit more detail. So what we're going to do is we're going to begin with a couple examples to give you an idea of how copyright primarily works. So we have something called the moonlighting problem, and that's a situation where you might currently be working in a business and you've approached your boss and you've said, oh, well, why don't you guys do this? And they say, oh, well, we're not interested in doing that. So you say, oh, I'm going to go and create this myself then. So you use potentially the confidential information that is owned by your employer. You then go and you work after hours and you develop a new idea and a new business. And then once you have that product ready, the minimum viable product ready to launch, you quit your business and you go off and work somewhere else, being your new business. Now, the situation or the problem with this is that it is a real possibility that the intellectual property that you have created is actually owned by your employer. And that's because when an employee works for an employer under the Copyright Act, as well as under common law and normally in an employment law contract, it says that anything that's developed by an employee for the employer is owned by the employer. And this generally, under the Copyright Act and under common law, it generally only applies to situations where it's you using the resources of your employer. So you're using their computer, you're using their confidential information, you're using their systems, you're using those processes. You're using their client data potentially to come up with the idea. And in those circumstances, that intellectual property is owned by the employer. There does become issues where um, it's outside of work, like where you're working after hours on your own home computer, then it becomes a little bit in doubt, and that's when you have to turn to your employment contract because a lot of employment contracts say that anything that you create or invent is owned by the employer as well, whether it's during employment or after. So the moonlighting problem is where you go and try to start your own business while working somewhere else that's using the information of your employer. And you could face litigation in the sense that they could go and file an injunction against you, stopping you from launching your business and seeking orders to what we call usurp the data and the intellectual property and to claim ownership over what you've just built after hours. So that's one thing. The main principle about this is that generally speaking, anything that an employee creates is owned by the employer. You then have the Zuckerberg problem, which is totally different and it's opposite. And in this case, Mark Zuckerberg was hired by the Winklevoss twins to develop a social network site. And in those circumstances, the Winklevoss twins had hired Zuckerberg not as an employee, but as a contractor. And the law is completely different when you have contractors. And the law is that anything that a contractor makes or develops for your business is owned by the contractor. There is no such thing as a law that says that intellectual property that is created by a contractor is owned by the principal. There's no such thing as an implied ownership or transfer of ownership. The only thing that could be potentially implied is a license to use it. Now, we'll go into this a little bit further in further slides, but why this is important? Well, if you're hiring a contractor that just developed your logo or your trademark or content for your website or your website itself or software, that's all owned by them. It's not owned by you. There will be an implied license that potentially you have a license to use it because you paid it. But then becomes a question of what kind of license. And the reason why a license isn't necessarily that great is because if you put input into what your contractor's making, and they've developed on maybe intellectual property that was previously owned by them, then in those circumstances, they can then go and start a competitive business tomorrow. So let's say you decide to terminate the software developer because you've now got your minimum viable product and you're going to bring in an in-house team to do the rest of the development. Well, they could just go and say, well, I can do this better than them. What I'll do is I will create my own competitive business. And in doing so, I will compete against them and do it better. And therefore, you've just paid for a contractor to develop all this intellectual property, and they've now own it so they can go and do whatever they want. So we'll talk about how to protect yourself in those two scenarios, but that's just to remember that an employee, the employer owns it generally, and for a contractor, the contractor owns it without a written agreement. Now, if you have any questions, feel free to drop it in the Q&A, and Joel will ask questions as we go. So the different types of intellectual property. So let's look at copyright. Copyright is what most people are familiar with. It is anything that you write down on paper. So it can be books, drawings, website content, software, algorithms, music, films, computer programming, all this stuff is all included by copyright. Now, what is copyright? Copyright is an original idea that is expressed. So what I mean expressed is we often come to a situation, and I like to use Ali G. I don't know if you've ever seen Ali G as an example, but Ali G goes to a capital raising organization, one of his shows, and he comes up with a skateboard and he says, I've just created the hoverboard. And the capital raiser says, well, that's great, but how do you create it? And he says, oh, I don't know. That's up to you to figure out. Now, coming up with an idea, like coming up with a hoverboard and holding a skateboard off the table, is not protected by copyright because it's not an expression of an idea. It actually has to be expressed in writing or expressed in music and recorded or expressed in a photograph or in photography or in a film. Now, without actually recording it in such a way, it doesn't have any protection. So an idea is not protected. And this is why it becomes really important when you're dealing with a potential partner or employee or someone that you want to do business with. And this is why we talk about non-disclosure agreements. And a non-disclosure agreement or confidentiality agreement essentially says that any information we give to you, you're not going to share with anybody else or use it for yourself. And at the end of our relationship, you're going to destroy it. Now, a lot of barristers will say that an NDA is not legally binding, is not worth the paper it's written on. And the reason for that is that 9 times out of 10, people sign an NDA and then they go and share their trade secrets. They share all their ideas and their plans and everything verbally. And sharing these ideas verbally without actually expressing them in writing, for instance, or a diagram, you're not protected. So, number one is if you're going to go into business with somebody or you're thinking about doing that and you sign an NDA thinking that you're going to be protected, well, you're not. You're two things. Number one is you're best off getting an NDA signed, number one. Number two, sharing what you want to share in writing so that if you ever need to prove that they've stolen your idea has been in writing and it's protected by copyright. And number three, withhold the important stuff. Do not share real trade secrets with anyone unless you have a proper contract in place. And a non-disclosure agreement is good, but a lot of times it fails because there's no what we call consideration. And to have a contract, so you might have heard of a deed as well. So let me just explain that very quickly. A contract has 4 elements. It has an offer, an acceptance, a meeting of mind, so people understand what they're entering into, and consideration. You're giving up something for the benefit of something else. Normally, that's money or time. So an employee will give up their time for wages. And without consideration, there's no binding contract. Now, the difference is that a deed doesn't have to have consideration. So you can still have a binding contract without the flow of money or consideration. And so oftentimes you'll see a non-disclosure deed because there's not necessarily confidential or there's not necessarily consideration forming part of that agreement. But I'll get into that later. But that's just a couple things to know about and some of the traps that you might face in terms of a non-disclosure agreement and someone stealing your ideas. The other thing that when we talk about non-disclosure agreements is that people will say they share their client list and then they talk to someone and then that someone goes and steals all their clients. And they say, well, we've just shared that information with you. You've breached the NDA. We're going to sue you. And they say, well, your clients are listed on your website. So anything in the public domain is not confidential information. And therefore, that's another pitfall in listing your clients, for instance, on your website. So copyright's governed by the Copyright Act. It's automatic. So the minute you express it in writing or in music or a photograph, it becomes owned by you. And it used to be back in the day, people would write something, they would put it in an envelope, they would send it to Australia Post, they would stamp it with the date and mail it, and then you would keep it in your envelope, never open it until the day you actually have to prove that it was when you actually created it, because you need to prove when you created it and who created it. But nowadays we have metadata in the email. So I always just say, well, email yourself from your work email to your personal email. There'll be enough metadata in there to show the date that you created that. Or you might publish it to your website. There'll be enough metadata there to prove when you created it. So one, you have to prove who created it, when it was created, and that it's owned by you. Other than that, you don't have to register it in Australia. In the US, they do have a registration process, but in Australia, it's just automatic. And it protects the idea so that people cannot copy it in substantial form. And copyright law can be very, very complex because, well, what does substantial form mean? It's looking at the entire thing in totality and deciding whether it's been substantially copied. So if someone just rips off your entire website and builds another one with the exact same thing, then it's likely, weighing it side by side, that it will be considered copying in substantial form. And that's literally what the judge does, is they weigh it up side by side. Now, there is a way where you can collate different kinds of copyright into one to make a collaboration of it. And that can be original works in its own because it has to take intelligent design effectively. It has to take some human intelligence to put it all together for it to be protected by copyright as well. Now, when you're the creator, you got to make sure that it has value and it can be commercialized. So it has to be something with the intention to be commercialized. A defense to copyright infringement is what's called the innocent infringer defense. And that's where someone says, I didn't know. So that's why you normally see the little C at the bottom of a document that says this is protected by copyright. And it normally has the year as well, because copyright only has a certain life. Sometimes it's 70 years, sometimes it's 100 years, depending on the situation. And so to prevent someone from raising the defense, the innocent infringer defense, that's why you put the little C saying this is protected by copyright. And every country has different copyright laws. Although when America was renegotiating the free trade agreement with Australia in 2005, one of the conditions of the free trade agreement was Australia aligns itself with the American laws. And so we came out with the Amendment Act, the Copyright Amendment Act in 2005, to align it to be similar to the American Copyright Act. And so what that means is that there are criminal offenses for copyright infringement. So for instance, there's something called a circumventing device. If you have a technology that needs a pass key to get in and someone creates a key that can circumvent that passcode, then in those circumstances, that can be a criminal offense because it's what's called a circumvention of a technological protection measure. And that's normally involved in software. So like the Microsoft key to get access to Microsoft. And if you were to use illegal keys, one, it's an infringement of copyright. Two, it's a circumvention of a technological protection measure, which means additional damages can be, you can be sued for additional damages, and it can have a criminal offense as well. Now, trademarks are different. Trademarks has to be something that's distinguishable. So it has to be something original, distinguishable, and unique. So for instance, you can't come out with a trademark calling yourself Sydney's #1 landscaper. Because if you were to do that, it means that no one else in Sydney is allowed to use the word Sydney landscaping #1 in all of Australia. And so what that does is that they only allow you to register a trademark that is unique and distinctive. It has to be different to others. It has to be first to register because with a trademark, you have to register it with IP Australia. And generally speaking, the first to register wins. So when you're coming up with a business name, I always give this as an example, you might get super excited that you went and you've checked GoDaddy and you determine that you can get the domain name of Sydney's #1 landscaping. So you get really excited, you get the domain name, you go to ASIC and you register your company called Sydney's #1 landscaping. And then you go and get a business name with the same. That does not protect your business in any way. All that does is prevent another company to register a company identically. So for instance, Lawpath has a trademark and it has a business called Lawpath Operations, Pty Ltd. Somebody can still go and register a company today called Lawpath Pty Ltd today because we don't have a company called Lawpath in its own right, just Lawpath Pty Ltd. We have Lawpath Holdings, Lawpath Operations, Lawpath Legal, but not just Lawpath by itself. And so just because and there's nothing stopping you from registering a company called Lawpath Holdings Incorporated or Lawpath Operational Services or anything like that, because ASIC only stops people from registering business names and company names that are identical. Now, what stops you from creating a company called Lawpath Pty Ltd is that Lawpath has a trademark. And that trademark stops anyone from using that name in the form of business services, legal services, online platforms, things like that. And because we have a trademark, if anyone was to register a company with Lawpath, the word in it, we can then send a cease and desist letter telling them to rebrand their company, change their name, or we will sue for copyright or for trademark infringement. And then we'll get orders that you are forced to change the name of your business. And we can also get orders for you to transfer all the profits that you have earned by using the name Lawpath to us because you've used a brand that is substantially the same to ours, riding off our brand to benefit your own business. And that allows us to take all your profits away. So a trademark is very powerful by giving you the exclusivity to your brand, whereas domain names and business names and trading names and company names does not do that. The other important thing about a trademark is that you could have your business right now and there could be no one else operating under that brand. But in 6 months from now, someone goes and creates a company with a similar name to yours and then goes files for a trademark and you don't know about it and then gets the trademark. They can now send you a cease and desist letter telling you to change your name, even though you were the first one that came up with that name. And that's because once the first to register wins. Now, there are ways to defend against that. Possibly over time, you might have what's called a common law trademark that you've established. You could potentially sue them for misleading and deceptive conduct and things like that. But a trademark is really what you're looking for to protect your logo, your slogan, your brand, your product name, your colors, your sound, your scent. The first one that came up with the color was the Cadbury purple. That was an uproar. People couldn't believe it, but they ended up getting it trademarked because they were the first ones to use that color. But examples of trademark is the McDonald's M, KFC, things like that. Now, as I mentioned, it has to be unique and distinctive. And it also can't be identical to anybody else. Now, this is what's interesting is that a trademark is registered in one of about 45 different classes. So for instance, I normally use the example is that there's a company called Barefoot that sells shoes. They have the trademark registered Barefoot under the shoe and merchandise class. There then is a company, Barefoot, that sells alcoholic beverages. They sell their alcoholic beverages under the trademark of the alcohol beverages class. So when you register a trademark, you're only protecting it in the class that you're registering your trademark in. So there could be Lawpath in business services and legal services and online education. But if you were a pharmacy, you could still probably use Lawpath if you want to, because a pharmacy is not in competition to what Lawpath is doing because it's in a different industry. So it can't be substantially the same or confusing to the consumer because you're in a different line of business. So when you register a trademark, you want to choose your class and you can go to trademark classification. If you just Google trademark classification search IP Australia, you can find that. And then you can type in your keyword and it'll tell you what class you want to register your trademark in. Now, sometimes you want to get several different classes, and sometimes people say, well, why don't you just register in in all of the classes? Well, one, it's expensive. Two, if you don't use it in a particular class, then someone can apply to strike it off on grounds of non-use. So you normally just register it in a class that you're operating in, or alternatively in one that you're intending to operate in. And if you're intending to do it, you have to have a business plan to establish that you intend to do it, and you must do it within 3 years. In 3 years. Now, trade secrets is it's effectively copyright. Trade secrets, once it's written down, it's a formula. It's something in writing. It is a trademark. You know, KFC's herbs and spices, the Coca-Cola recipe. People don't want to register these, and this is why a lot of times people don't get patents, because if you get a patent, you actually have to disclose your secret and then protect it. And people don't want to disclose their secret. And so that is why sometimes a trade secret isn't written at all. It's just in someone's head, potentially. Um, and but obviously that's not very safe, because if that person passes away or if they get dementia or whatever it is, then there's a serious problem. So a lot of times, if you want to protect a trade secret, let's say you're manufacturing something, you will have an assembly line and you'll have different manufacturers doing different pieces and then assembled somewhere else, so that each manufacturer only knows one component, and that way they can't do it all in one.
Excuse me, Damon.
Yeah, go for it.
The lovely Olivia Ward has asked, can you pay to trademark under multiple classes if you might swing between both?
Yeah, absolutely. So you can get several different classes, and when you apply, you can choose a couple different classes if you would like to. Each one has a separate fee. Each one is deemed a separate application. Um, but um, but there's no problem with that. It's just you have to plan on getting into the other area, and actually get into that area and use your trademark as a trademark, which means use it as part of your business in each of your classes. Does anyone else have any other questions on trademarks while we're on this topic?
Oh, I'd
All
say we're
right.
good for now.
Okay. So the next thing is also making sure that before you do a trademark application, do a search. You can go to IP Australia trademark searches, and there you can see whether anyone else has the similar or same name to what you're intending to register. And if they do in the class that you're registering in, then in those circumstances, you're going to be rejected. You're going to get what's called an adverse report, and you won't be able to get your trademark. Now, if you're not able to get your trademark, it means that that person that does have the trademark could come after you later, claiming that you're infringing upon their trademark and making you rebrand your entire business. So you might spend a lot of times on marketing and advertising and branding your company, only to find out that um, that you have to rebrand as a result of you infringing upon someone's trademark. So some things to consider is you want to protect it, you want to register it if it's copyright, you want to write it down somewhere, have it protected that way. You want to know who's created it, when it was created. If it's just an idea, it's not protectable, so you've got to actually express it as an idea. Now, when we look at a non-disclosure agreement, as I mentioned, it is good, but it's not concrete. So you want to have, if you're going to be sharing information with someone else, you want to have a non-disclosure agreement because it acts as a deterrent. But there's ways to get around it, in the sense that if the information that you're sharing is already in the public domain, then there's a possibility that it's not protected, because anything in the public domain is not protected from disclosure. It's not deemed confidential anymore. If you are just talking about an idea, that's not going to be protected. And just remember that if you believe someone's breached the NDA, you have to then prove it. And the question then becomes, how do you prove that they've just started up that competitive business using the information that you just gave them? And that's very hard to establish. So you want to, if you are going to use the NDA, you got to make sure that you have you're withholding some of the stuff, because if someone does breach that NDA, it's going to be hard to enforce it by suing them for breach of contract in court unless you have the evidence that their breach, that you can actually prove that what they've done has actually breached the NDA by disclosing your information or using it. And that's why we always say, do not share all your secrets during the preliminary stages. Withhold some of the information and the most important stuff like client lists until later on, once you actually have a contract in place. So for instance, if you're going to sell a business, you would do an NDA, talk about possibly the revenue, not give them your contact list. Once they sign the contract to buy your business, you would be subject to a due diligence clause that allows them to get access to the client list, but you would have protections built into the sale business contract, and the contract price can be adjusted based on any findings in the due diligence agreement or under the due diligence clause. But you don't want to share client lists, trade secrets without a proper contract in place.
Damin,
Now, yeah, go for it.
sorry to cut in. Anne Hawley has asked, can I trademark my firm's name if it has the suburb name in it?
Potentially. So, for instance, if it was Hawley's um, Sydney accountants, then probably yes, it's distinctive. It's distinctive. Um, it can be it's different. But if it was, for instance, um, Chatswood or Burwood um, accountants, probably not, because it's not unique, it's not distinctive, and you're stopping any other accountant in Burwood or Chatswood from being able to use that word with the word accountant. So it's unlikely to be unique enough to get registered. Now, there are ways around it. So you could say, for instance, Chatswood's accountant, um, always available, always free on time, and you put it all together with your slogan and your name, and it's all as one, then you might be able to get it. Or you could do a trademark with your logo and your name built into that logo, which might be distinctive enough to be able to get it. But just the word itself, probably not.
Thank you, Damon. And another one from Andrew Robinson.
Yeah.
What should you consider when trademarks and IP are transferred in a purchase? If trademarks from a seller have expired and they are in breach, how would the purchaser protect themselves?
If the trademark's expired, sometimes there's still some time, even from the expiry date, to renew it. If not, it's gone forever, and you would just have to go and register a new one. It would definitely be unfortunate because we have something called priority dates. So when you make your application to protect for a trademark, that's your priority date. And I'll just talk about this briefly, is that, so let's say you lodge an application today on the 4th of June, your priority date becomes the 4th of June. And that's the date that it's effectively protected as long as once it gets registered. Now, if you want to go and file a trademark in America in a year from now, you can go and just file an application in America, but the priority date is the date that you file. Whereas you can use what's called the Madrid Protocol, which is through the World Trade Organization, to leverage your existing trademark in Australia to file a trademark in America using the priority date from today based off the Australian trademark. So if you had a trademark from 10 years ago, and it's expired completely, you've lost your priority date, but you probably still have a common law trademark in the sense that you can prove that there has been goodwill created over years. And if anyone was ever to start up a business to specifically compete against yours, you could say that they're doing that using the same name to mislead and deceive the consumer. And you could potentially go for misleading and deceptive conduct. You might also go for trademark infringement. because you might own the logo, or you could say that your slogan is protected by trademark potentially. But the best way to protect yourself is to go and register a new trademark so that someone else doesn't come along and start up a new business and register a trademark that's the same as your existing business. Now, if we look at patents, patents are very much different to trademarks and to copyright because it's confusing. But in America, we have attorneys, and an attorney is a lawyer. And in Australia, we have attorneys, but attorneys are not lawyers. In Australia, we have patent attorneys and trademark attorneys. And generally speaking, with a patent attorney, they first have to have a science degree. So, for instance, if you just made an algorithm or a computer program, you will hire a patent attorney to apply for your patent. And that patent attorney will normally have a computer science degree with a master's to become a patent attorney. And so they then have the know-how to understand the algorithm, the source code, to be able to then develop the patent to make sure it's as protected as possible and as broad as possible to give you the protections. Same thing as if you're a chemist and you come up with a chemistry compound, you would hire a patent attorney that has a science degree in chemical engineering or chemistry or biology, and they are the ones that are your patent attorney. Lawyers are not patent attorneys, so we don't draft applications, and so that's the main difference. So that it's kind of confusing, but we're not attorneys. Lawyers are not attorneys. So if you want to get a patent, you got to go to a patent attorney. Lawyers come in though when it's time to enforce it. So I'll just briefly touch upon what a patent is. It's an invention. It has to be new. It has to be innovative. It has to be capable of industrial application, meaning you have to be able to commercialize it, and that you have to you can't disclose the invention and how you've done it to the public until your patent has been applied for. So those are the main elements of a patent. And that's all I'll do today about patents. But if there was a breach, the breach is similar to a trademark infringement. You would be able to sue under the Patents Act, and you normally have a patent attorney to give expert evidence explaining the technology and the invention and why the other patent is infringing upon it. And then you would also sue for copyright infringement. You would also sue for misleading and deceptive conduct and all the other elements for the other areas of law. So that's about it in terms of the main ones. The next, and a patent and a trademark and a design are all registered with IP Australia. A design is different to a patent. A design is like the Lego brick. It can be the Omo-shaped bottle of the product. It's normally shapes and things. For instance, if you're into off-roading vehicles, you have a roof rack. That roof rack is normally a design of how it's just shaped. Bull bars might on the front of cars be another design as an example. And the same kind of process is as a patent kind of where you upload your design and then you apply. And the requirements is that you have to have drawings, you have to have images to demonstrate the design. Once it's registered, it's only for 5 years, but you can renew for another 5 years. It only protects you in Australia, and then an examiner will examine the design. So when it comes to enforcement, at the end of the day, all this is great, but if you don't unfortunately have the funds to protect it, that's where it becomes difficult. So if someone has copied your copyright, or if somebody has infringed upon your trademark or your patent or your design, the first step is you normally send a letter saying, you are doing this. We want you to undertake to change the name of your business, transfer over the domain name, remove all the branding, stop using the trademark, stop using the patent. And if you do not cease and desist, then we will, and sign this undertaking, then we'll sue you. So that's great. Now, a lot of times people don't respond to a letter of demand or a cease and desist letter. So the next step is that you would actually have to engage a lawyer normally. And there's two processes that you can generally take. One is you can apply for an urgent injunction. So you can apply to the federal court and seek orders that they are immediately ordered to stop using it until a final determination from the court is ordered. Or alternatively, you can just sue for the breach and let them continue on using it, accrue all the damages, and then when you go to seek damages, you can choose for the damages to be the proven loss and damage that you've sustained as a result, or it can be account for profits, usurping all of their profits that they've generated from your brand and transferring all their profits to you. And that can be an expensive exercise because once you're in the federal court or a Supreme Court, it can be an expensive exercise. So it's good to have all these protections in place. It's then very difficult to enforce it. But at least if you have those rights, you can send those demands. If you do have the funds, then you can enforce those rights. And generally speaking, you can enforce those rights for a period of 6 years. So even if there's an infringement, you can give notice of the infringement. If they continue on doing it, you don't have enough money just now, you can wait until you do have the funds to then go and sue. But it is really important that you approach a lawyer right away if someone's infringing to know exactly what you should do, even if you don't have the funds to enforce it at this time. It's normally, at the very least, putting them on notice of the infringement, because once you put them on notice, in those circumstances, any continuing infringement is normally what's entitling you to additional damages on grounds of flagrancy of the breach. So I'll leave you for now on that. If you have any other questions, drop them in the Q&A. I know I find the Q&A is the most valuable part of these kind of presentations. Joel's going to jump in for a moment, and I'll see you back in 5 minutes.
Thank you so much, Damin. For those who have asked some questions, we will get to you guys shortly. So thank you so much for your patience. I do hope everyone is enjoying this webinar so far. We do love questions. It's yeah, some people might feel like they don't have the right questions to pose. So if someone else asks a question that's a closer approximation, it might be exactly what they need. So feel free to bring them in, and we can get through those together. Now, with Lawpath, I'm sure you're all familiar with Lawpath, otherwise you wouldn't necessarily be here. But if you're still tossing up whether to ever consider us for assistance, I guess the bottom line is, instead of hiring multiple professionals at high hourly rates, Lawpath offers unlimited access to senior lawyers and chartered accountants and tax agents through affordable subscription plans. Now, personally, I don't know about you guys, but when I hear the word subscription, it's quite an icky word. I'm not very fond of it. The good thing about Lawpath is all of our plans essentially have two options. You've got quarterly or you've got annually. So if you are looking to get assistance for your business, but it's maybe in the early stages and you are fluctuating through clientele or cash coming in, it's always nice to know that with Lawpath, you're not going to go, oh crap, here comes a monthly bill. We just don't have the money to pay for this. You pay at the start for annual, for example, and you have complete access, peace of mind, tax deductible, all that jazz. There are always going to be, I'm sure you can all agree with me here, there are always going to be landmines throughout the year, whether you're very well established with your business or if you're just starting out. And you can scramble to try to figure things out, go into ChatGPT, go into Google, speak to a friend who's been doing this a lot longer than you in the same business, or you can just click of a button, hop on a call with one of our professionals, your lawyer or accountant with Lawpath, and they will be able to sort you out instantly. Sometimes in regards to accounting, for example, as I mentioned, this the last couple of months have been very much accounting and tax based with our webinars. So it's a big thing for end of financial year in BAS. I found a couple of clients say, I had a question that took 2 minutes to answer from my accountant, and I was charged full price instead of just hopping on with Lawpath and clicking a button and getting that free consultation and having a yarn as well. So I'm not wishing to step on the toes of any legal or accounting professional, but if you guys are looking for something that's just a bit more convenient, you can stay in your office, you don't have to drive out to speak to that professional, our plans are the perfect option for you. The legal advice plan gives you unlimited 30-minute consultations with expert lawyers, all based in Australia, I should mention. All lawyers and accountants are over here. All of our accounting teams are in Sydney, but we do have lawyers in most states of Australia underneath our umbrella. We like to keep our finger on the pulse of legislation and rules in different states, so that's why we have our lawyers in different areas. Unlimited contract reviews, HR, employment, commercial advice, and access to over 500 plus legal documents. So if you are new and you've never really played around on Lawpath, if you make a free account, you've got access to our Lawpath AI whenever you want. Ask it when BAS statements are due. Ask it to break down a contract for you, for example. Ask it what would be the best contracts for me to use, things of that nature. Now, we appreciate that you aren't dumb. You are not dumber than the lawyer. Contractual law isn't the most complex thing in the world, but it is always, always vital to have someone, legal professional, for example, reviewing what you're working on. And these webinars are a perfect example of why you just can't get too complacent with some things. So if you do just want that extra bit of security when it comes to reviewing documents, both internal or external, or assistance with hiring your first employee or branching out of state or whatever it may be, building the brand, we've got you covered with the legal advice plan. It is usually $1,668 per year, but it's down to $1,504 because of our end of financial year discounts. So if you guys are looking to make a bit of an investment that's going to assist your business moving forward for the remainder of the year, then certainly it's a solid investment. On the website, your homepage with all the options, you can go to consultations, legal, put in your brief, pick the lawyer you want to speak to, or just choose best lawyer for me. Date and time, video call, phone call, and then it should be able to book you in. No more than a day usually. You'll never have to wait 4 or 5 days to get a legal or accounting consultation with Lawpath. If you have your first call with the lawyer or accountant and you like them and you like their services, you can just say to them, hey, I want you to be my go-to person from this point on. And at that stage, you will just have one person to speak to. You don't have to worry about speaking to someone new each time, and you'll likely have them on your Christmas card list for sure at the end of the year. The accounting advice plan, same premise as the legal advice plan. It's very DIY, but we are offering that support. So it gives you unlimited accounting consultations with a senior chartered accountant. If you go into the Lawpath platform and go partner offers, we have just created a partner offer with Xero. I believe it's 90% off for the first 6 months. Now, all of those partner offers, whether you're on a paid plan with us or not, they're all available for you guys to use whenever, and they will not expire. GoDaddy, Xero, MyOb, whatever your option is, they are there for you to use. Now, if you're on the accounting advice plan and you decided to merge over from a bookkeeper or just start fresh, you would hop on the accounting advice plan. Your first consultation, you just express everything that you're going to do with your business. They would right then and there on the video call set you up on your Xero account, show you how to do it. And then moving forward, every time you have invoices come through, things you're investing in, payroll, paying yourself as a director, that's just an example, GST, preparing for BAS statements, all of that can be covered on those calls. So you can essentially be running all your own accounts and have a professional just reviewing what you're doing, and also offer extra advice if you are either reporting things incorrectly or if you just can't get your head around a specific topic. Same price as the legal advice plan. $1,668 is now dropped down to $1,500, and that is paid up for the entire year at no extra cost. And then finally, we have our tax plan. This is not like the legal and accounting. This is just straight up us doing all the work for you. And it helps if you're on the accounting advice plan, so we could just open up your Xero or MyOb account, look at what you're doing. Obviously, all your books are neat and tidy because you've had an accountant assist you, and then just we take over the rest. We will do all your BAS statements for you. end of financial reporting, tax returns. We also offer to do your personal tax return as well. So if you have a spouse or your business partners, for example, if you want us to do both business and personal, I think it's only like $100 extra, and we'll go ahead and do that for you. That's usually $3,600 for the year, but we've dropped that down to $2,500 as well. And look, guys, we also have extra discounts on top of these as well. So if anyone is interested in I guess just at least considering some of these, maybe not now, but in the future. At the end of this webinar, just go ahead and type in, Joel, please contact me afterwards, or throw in a yes in the chat. It's just a friendly consultation call. I'm not necessarily going to try to push the sales down your throat. It's more to say, let's qualify what you've got going on. If I can determine that you will need assistance, I will offer that to you. Otherwise, if we can come to an agreement that you're probably not going to need anything until X, Y, and Z time, then we'll just schedule a follow-up with each other later on. So that's not a problem at all. We also have the what we like to call first year business starter package, or a hero package. If you wanted the legal, accounting, and tax all in one hit, the 3 pillars of success, then you can go ahead and grab that for $4,738 per year. Now, Nick Ross, you said free consultation. So we have a free accounting consultation if you're on some kind of plan, or if you register a business or a company with us. Unfortunately, we don't offer free legal consultations. Otherwise, I feel like half the population of this country would be abusing that, and those hardworking clients who have actually paid for subscriptions wouldn't really get a chance to get an availability. So I do believe we might be offering a free tax consultation. I will get back to everyone on that in the email that I send out, but you can definitely, if you've registered a company or a business or any other kind of plan with us, you will get a free accounting consultation where they'll just sit down and go, let's look at what you've got going on at the moment. Are you transferring something over? Are you buying a business? Are you bringing on an employee for the first time? Are you merging from one accounting software to the other? Let's help you walk through all that together. That should be done within 30 minutes on that call. We have 30% off on pretty much all of our plans at this point in time. This will all be available in the email I send out. Or if you just go into your free account on Lawpath, you can see all these wonderful offers as well. And yeah, look, that should be everything. As you can see, I will send these slides out and the email with all this information available.